Guatemala, even though TECO is trying to say that Guatemala should be happy with the result. Therefore, in this case, we also have a manifest excess of powers by the tribunal according to Article 52(1)b of the ICSID Convention, and two, the failure to state reasons for the award according to 52(1)e of the ICSID Convention. Because of the defects in the award, and also contrary to the arguments presented by TECO, meaning that this annulment is just a pretext to delay payment, Guatemala has used their right of defense by presenting this annulment proceeding. In this regard, we are certain that the annulment committee, in their work to protect and guarantee the ICSID system to settle differences, will address in an impartial manner each of these defects, and this clearly implies the annulment of the second award. Finally, and as expressed by the Vice Minister on Integration and Foreign Affairs with the Ministry of Economy for Guatemala, direct foreign investment is key for our economic development and also for the establishment of a mutual relationship. The state is committed to attracting foreign investment that is responsible and quality investment, as well as the compliance of protection standards for investors as stated under free trade agreements and also the BITs signed by Guatemala. I thank you all for your time and attention, and I give the floor to Guatemala's counsel, who will be sharing with you our closing remarks. Thank you very much, Attorney General. Mr. Tortola. Thank you very much, Madam President. I will continue in Spanish. And next, Mr. Smith and Mr. Gosses will be speaking in English. First, I would like to say, and I am not blaming here the annulment committee, but closing statements are no longer done in most of the proceedings. This is just to tell you that I have slept only 2 hours and that I will do my very best to give my best and to give the best of the team to explain all of the issues that have been presented here, but please bear with us since we also had to be able to be here today to start at 10 a.m. So it was a very long night. But I hope I have the possibility to have another opportunity to address you in due course. But we will try to address each of the topics as needed. I also want to share with you, and I want to tell you that I am not happy to be talking about a professional individual by calling that person by or referring to someone by name and last name. Things are easier when we do not have a name and last name, but it is our obligation to be here today.
It's my obligation and your obligation as persons who have been chosen by the Secretary General and have been accepted by the parties. I would also like to inform you that yesterday our colleagues began their statements by saying that this is one of the longest lasting or longest standing proceedings. And I actually took the trouble to look back over the dates. It started in December of 2013. There was then an appeal put forward by TECO that on the 5th of April 2016 received an award. There was then a new submission proceeding initiated to get even more money from Guatemala that finished on the 13th of May of 2020. And I'd just like to ask if it's possible to make the accusation that this is such a long proceeding and that it should be blamed upon Guatemala. This case deals with some very important issues, as has just been stated by the Attorney General, and many of these causes are groundless and will have to be paid for out of the public pocket. And for many countries, and for Guatemala, my country, these countries are poor countries, and so you have an enormous responsibility on your shoulders and must therefore be cautious. It's not an issue of time and whether it's going to take a month more or a month less. It's a question of giving the parties the opportunity to fully put forward their case and to be heard. The dispute resolution mechanism in investment disputes is extremely valuable and important, and until recently wasn't subject to international law. And in fact, the subjects of international law are the states themselves. And the system of human rights now gives individuals the opportunity to put forward a case in exceptional cases and should not be used as a mechanism against the fundamental legal principles and pressure countries and say, this is my money, give me back my money. The claimant's lawyers said yesterday that they do not agree with the tribunal's decision in this resubmission proceeding. And in spite of the fact that there has been an award against Guatemala, we disagree with the claims that have been presented. If they have the right on their part to say they disagree with the award, the state also has the right to say that they are in disagreement with the award that has been rendered. The next point I'd like to address, if we could go on, please, to the next slide now. Next slide. These are the issues that we're discussing as grounds for annulment and the failure to state reasons. Here in paragraph 98, the tribunal, without saying why, says that the tribunal has decided to accept the figure identified by Mr. Kaczmarek as the actual value of EXA at the time when DECA was sold. The tribunal bases itself solely and exclusively on what Mr. Kaczmarek said. And if we move on to the next slide now, there are two possibilities that were discussed during the proceeding with in reference to post-sale damages when the shares in TECO were sold. One possibility was US prime rate +2, as put forward by Mr. Kaczmarek, and the risk-free rate that was proposed by Compass. You'll know that was accepted by the resubmission tribunal, and I'm not going to get into that discussion here, was mentioned and will be addressed by Mr. Gossis, but it was said that a risk-free rate cannot be applied because the assets are no longer exposed to the commercial risk. And on the next slide, we'll see what the tribunal decided. They decided to accept the prime rate plus 2%, which was Mr. Kaczmarek's position. So I asked myself whether if Mr. Alexandrov had disclosed his circumstances that we're all aware of and have been the subject of discussion, what decision would Professor Lowe have said? Would he have held the same position? Why, or would he have explained at least why Kaczmarek's position was adopted? If we go on now to the next slide, as the annulment committee in the ISA case said, the committee can conclude, and we're in paragraph 251, that as a consequence of the failure to disclose, Spain lost the possibility of a different award. And I would ask of you that when you retire and when you are deliberating, that you give some thought to your role as arbitrators. And I would ask you to ask yourselves whether you would agree with Mr. Kaczmarek, even though you know that there are other relations held by him. Would your decision be different were those relationships not to exist, had circumstances been different? And the fact that Mr. Alexandrov focuses his activities on damages, I asked my team, as I said yesterday, to do a search. Our team from Guatemala did a search, and the issues surrounding Mr. Kaczmarov focused specifically on damage evaluations, as we've said. So again, the question is, how much of what was said in the award actually could have been written by Mr. Alexandrov himself? Excuse me, Dr. Tortorola. So are you saying that Mr. Alexandrov was more involved in damage calculation than in res judicata? There were so many issues that were discussed in the second tribunal. As I said yesterday, we've taken a very close look at the transcript, and there was a lot of focus on grounds and damage quantification. And Professor Lowe and Professor Stern focused their questions on grounds, and Alexandrov's questions focused on damage quantification. So anybody who knows Dr. Alexandrov and has met him in other cases will know that those are his areas of expertise and the areas that he prefers to focus on. So I'm simply saying to this annulment committee that this is of concern. Sorry, if you'd allow me, I'll continue. Yes, go ahead. Also, yesterday it was said that the request for a stay of enforcement of the annulment had been made by Guatemala in poor faith. You can see that on the screen. the bad faith nature of Guatemala's application. And as has just been said by the Attorney General, how could we ask for a specific remedy, or how could we not, as it's part of the ICSID mechanism? I mean, why is it bad faith when we're asking for the rules to be applied, where we're faced with an annulment of an award rendered by a tribunal? When was the ICE award actually annulled? It was on the 11th July or June of 2020. So it was that award that enabled Guatemala to become aware of the situation and what had happened. So there is no bad faith. No one has set a trap for anyone, nor has anybody tried to extend the application of an award. There is no speculation because we can talk about specific dates when things have happened. I think one needs to be cautious here. We're all colleagues. We are all doing our jobs. And to talk of bad faith on by one of the parties is something we need to be cautious of. And a number of things come into play. I'd like to say that the lawyers sat here. We began to work in 2020 with Guatemala, having been selected by open competition to represent Guatemala from a different perspective than our learned colleagues opposite. I'm sure my colleague, Mr. Quinn Smith, will further explain what I'm referring to. Anything that happened before our involvement is nothing to do with us. We came into this situation in 2020, and we have tried to ensure that the embargo on Guatemala's assets be lifted. But as I say, my associate will explain the reasoning and the defenses put forward by another very prestigious firm of lawyers and the arguments put forward by those lawyers in Washington. And as the Enron Committee has said, that the absence of particular reasons and evidence, for concluding otherwise, the committee must assume that the application for annulment is made in good faith. So before I move on to look at Article 52(1)(a), I'd like to answer the question that was asked yesterday by Professor Jones. I'm not sure that I 100% understood your question, sir. I wrote it down and I have read it back to myself, but if you think I'm not actually answering the question that you asked, I would ask you to reformulate the question and I will make my best effort to answer that question. And to some extent, I yesterday tried to explain that I thought that in the ISA case, the Annulment Committee had already expressed its opinion on this issue. But I do think that if one thing comes across, Professor Jones, in your article, it's that same concern that has been expressed by the Annulment Committee regarding the independence and impartiality of experts and the efficiency and effectiveness of experts, given their independence and impartiality, and that that's what's at stake and their convictions are also at stake due to a too close a relationship, perhaps between counsel and experts. You begin by looking at the relationship or the situation of experts who are hired by lawyers to prepare cases, and how in some cases they help to prepare the case and then are engaged as independent experts, and what's said in the different protocols that try to resolve this issue. And as I said yesterday in the ICER annulment committee, they had the courage to say things that all we lawyers know, but we don't say out loud, because it's all part and part of a system, a game that we have agreed to take part in. And in this article, it says something very similar to what was said and written by the annulment committee in the ICER case. And they say that it's of concern, the relationship that exists between counsel and experts. We have a very good damages lawyer amongst us, as you saw yesterday, Mr. Gossis. But it's also true that these lawyers prepare the cross-examination questions for the other side, and you know that that is the case. And we looked and look at the situation of an independent expert. I mean, what about the questions in the TCC case from Mr. Alexandrov, when there was a discussion about the duty to disclose, and it was said that all experts are independent, but that's not the case. And you, Professor Jones, have cited a study by Quinn, Mary, and White and Case that says that 90% of all of those surveyed have doubts about the impartiality of experts. And look at the date of the survey. That's 2018, at the same time when all of this was happening. I do hope I've answered your question, but if that's not the case, then I'd be very happy to go back over it. As I've just said, I only had 2 hours sleep last night. Your article is some 45 pages long, but I read it from beginning to end so that I could respond, answer your question. And I also read the transcript back in order to answer your question. But I wanted to answer the question you asked yesterday. Had the ICER committee considered these issues? I believe so. But if we focus on one paragraph, 227 or 228, I think, and I did show you those paragraphs yesterday, perhaps I didn't go into enough detail, or perhaps I didn't put forward a kind of protocol. But I think it does, and I think I've shown that it expresses those same concerns.
Thank you, Dr. Tortorella. My article is usually an adequate cure for insomnia. But can I just try and summarize what I understand you to be saying? And that is, in this article, I identify the requirement for efficiency in arbitration of party-appointed experts to be independent and assist the tribunal, which necessarily should bring a level of some distance between counsel and those experts. But you say this principle is more honoured in the breach than the observance. Would that be a fair summary of what you're saying?
Yo creo que sí, que es
I think so. I think that that is a very good observation. And I think it's kind of a circular reasoning, if you like. So basically, what you're saying is that because the problem exists, it needs to be resolved. In order for the experts to be credible, and I really have to say, I fully agree with you. I don't have the same prestige that the members of the committee have, but I have been an arbitrator from time to time. And I think that there must be a third party involved in many issues, but damages is a very complex issue, and $1 million more or less is not the same, especially when claims are being made for, excuse the term, ridiculous amounts of money. And for the public, the Treasury, $1 million up or $1 million down isn't the same thing. And it isn't for me either. If you were to give me $1 million, I'd be extremely happy. And a number of things that I can think of right now off the top of my head that I could invest that $1 million in. But if we, well, and I'd just like to point one or two things out here. One is to do with the relationship between experts and arbitrators. This is nothing new. Mr. Gossis showed me today a document that is on the record, the book by Karen Kaplan on the UN CITRAL, and it has to do with Amoco versus Iran, and it refers to the close relationship between Morgan Stanley and its experts. But what I'm getting at is that once again, ICE has made an enormous contribution here, and I'd like to point out two things in this respect. First of all, the arbitrators, at least two of them in this case, were external to the system, and Ricardo Hernandez has started doing cases now, and having a judge from the Court of Cassation in France, which only hears annulment cases, does bring a different perspective. So what we have to consider is how we are seen by third parties, how the parties see us, how a layperson to whom we might recount the case, or how people see and understand what we do. And I thought to myself, well, my brother is a doctor. He might ask why Mr. Blackaby from Freshfields, you may or may not know him. I respect him highly as a professional. How he has presented himself or not. I mean, like doctors, they may lose a patient here and there, and when they're unknown, it doesn't really affect them. But when it's somebody close to us, we feel it. So we have to give consideration to these issues. We have to consider the relationship between the parties and the experts. And we also need to understand how people outside of the field in which we operate see us. It's like we have to ask ourselves, how are we seen from the perspective of outsiders? What about our code of conduct? We have to consider the positions of the parties. They're disgusted often by what goes on. We'll be like dinosaurs. Suddenly a meteorite will hit the earth and we'll all be completely wiped out because we're not respecting, we're not upholding those things that we should. I'm sure I've run over time, but I'd just like to finish by saying that Article 52 must be read together with Article 30 of the